Hello viewers. In the last session, we learnt about the scope and the salient features of the Act. In addition to that, I also introduced you to chapters 1, 2, 3, 4 and 5, which laid down the actual legal structure governing the competition. In the chapters that I am going to deal with right now, chapter 6, chapter 7, chapter 8, chapter 9, I will be dealing firstly with the penalties, which become very important, which actually gives the strength to the Act. The chapter 6 deals with the penalties laid down under the Act. Sections 42 to 48 deal with the penalties laid under the Act. Let us understand what kind of penalties are laid under the Act. Friends, please note that this chapter becomes very important because it prescribes different penalties. There is an imprisonment for contravention, there is a penalty imposed, and there is a compensation paid if there is a delay in paying the penalty. These are the three guiding principles so far as the penalty chapter is concerned. Let us go one by one in each section. Section 42 talks about contravention of the orders of the Commission. Now, this becomes very, very important. In the previous chapter, under chapter 5, you have learnt about what orders can be passed by the Commission. Now, here under the penalties chapter, that is chapter 6, 42 clearly says what penalty can be imposed by the Commission if its orders are contravened. I am not getting into the detail and reading of the entire section, but for the sake of understanding, I will tell you it can impose a punishment up to 3 years and fine can go up to 25 crores. This is subject to us reading the section once again in its entirety when we come back to our next session exclusively on chapter of penalties of this chapter 6. Going on to the next section, that is section 42A, talks about compensation in case of contravention of the orders of the Commission. Now, this is also relevant. As I said, contravening the Act, contravening the orders of the Commission, there is a penalty, and under 42A, it provides for a compensation in case the contravention of the orders of the Commission. Penalty is one aspect of it, which is dealt under 43. 42 has a different thing. It talks about compensation. They are two different things. For the purpose of understanding, as I said, penalty, compensation, and also some sort of imprisonment is provided under both these sections. Moving on to section 43. Section 43 talks about penalty for failure to comply with the directions of the Commission and the Director General. This is also very important. So, basically, as we looked at chapter 5, Director General has been conferred with powers to act upon any person, to impose any kind of a stricture, but the powers conferred upon him when there is a contravention of any of the provisions of the Act. Now, that power is strengthened by giving section 43 in form of a penalty. So, it clearly lays down that whenever there is failure to comply, not with the orders of the Commission alone or any directions of the Commission alone, but also the Director General, what is the penalty imposed here? The penalty that is imposed is rupees 1 lakh of each day in failure to adhering with the directions of the Commission or the Director General, and it can go up to a maximum of rupees 1 crore. The penalties are quite high. You may be wondering, why is the Competition Act imposing such heavy penalties? It is required because of the kind of players involved in regulating the markets. To ensure a strong deterrent is there, these perhaps it was the wisdom of the legislature that such penalties have to be imposed to regulate giant monopolies. Section 43A, there is certain power conferred upon the Commission to impose a penalty for non-furnishing of information on combinations. Sometimes, as I said, the Commission in course of its inquiry or in course of discharging its duties or suo moto may feel certain combinations are acting anti-competitive, and it may call upon them to supply certain information. And if such information is not provided, then 43A comes into play, confers a power upon the Competition Commission to impose a penalty on such combination which fail to provide the information. Now moving on to 44, a penalty for making false statement or omission to furnish material information. This is also important. If you look at each of the section, each section is supporting the other and giving strength to the chapters, earlier chapters, which is conferring powers upon the commission. Please understand, power backed by a penalty. Now this becomes very strict, and more power, the power conferred upon the commission gets stronger for implementation purpose as well. It is important because when you ask certain information, you are mandated to disclose such information, and when you don't disclose such information, there is a penalty, and there is also, it is considered as an offense. Penalty plus offense, both are important. Furnishing of information when called by the commission becomes relevant. Therefore, power to impose penalty in form of section 43A and section 44 becomes relevant. Now moving on to section 45. 45 also complements section 44. It talks about penalty for offense in relation to furnishing of information. See, we are dealing with two things here. One is call to furnish information. Two, when you have to furnish correct information, you don't furnish correct information, false information will also lead to prosecution and imposition of penalty, and also it is made as an offense. Moving on to section 46. Now this is kind of a special power. Suppose this basically, before I tell you what is special power, let us examine what is 46. As it speaks for itself, section 46 talks about power to impose lesser penalty. Now why is this it need to be provided to the commission that it has the power to impose lesser punishment? Now this is important because, like the law, you go by strict interpretation of the law. The law says this is the penalty and the highest penalty is this and highest award of sentence is this. But if you do not confer a discretionary power upon it to understand imposition of penalty based on the quantum of the offence violated, or the quantum of the offence committed, or the quantum of the contravention done, it should be proportionate to the crime committed. I am using crime because crime is more seen from a criminal perspective under IPC regime, but to apply such a logic to the understanding the competition commission imposition of penalties, it is relevant. Therefore, perhaps it was felt necessary that the commission should also be conferred a power to impose a lesser punishment in form of section 46. So therefore 46 also becomes very, very relevant. Section 47, next section, it talks about crediting of the sums realized by way of penalties are to be put to the consolidated fund of India. Now this is relevant. As I said at the very outset, if 42 can impose a penalty or some sort of a monetary penalty to the amount of 25 crores, then this amount has to move somewhere. It has to be sent to the consolidated fund of India. It has become relevant. Therefore, if it goes to consolidated fund of India, its utilization comes to a better purpose under the guidance of the agency that controls the consolidated fund of the government. Therefore, it was felt necessary that these penalties will move to the consolidated fund under section 47 as a mandate. Section 48 is an important section that talks about contravention by companies. Most of us understand the entire business that it runs today is primarily run by companies in various forms, a sole proprietary company, a partnership company, or a private limited company, or a public limited companies. Whatever form you call it, they designate themselves as companies and conduct business. There is a special provision for dealing with offences committed by companies. Section 48 deals with all those contraventions by companies and the penalty that can be imposed under the chapter dealing with penalties. The next chapter is chapter 7. It talks about competition advocacy. Section 49 of the Act lays down a mandate that the Competition Commission is also entrusted with the responsibility to frame a competition policy from time to time. The term advocacy in a common parlance is understood as on your behalf, means some responsibility is conferred where you advocate. Each time you say advocate, we on behalf of the nation or the competition commission on behalf of the nation advocates for there being regime in the trading which is guided by good principles of competition. So therefore, from time to time commission is mandated to frame a competition policy, and such policy, the uniqueness in this section is a policy framed by the competition commission has a binding effect, and the government of India may adopt it for the purpose of enacting a law or to improvise the law to ensure that it has an effective implementation. So the underlying principle to understand through this section is the competition commission has a responsibility to frame policies dealing with competition issues from time to time. Moving on to the next chapter. Next chapter is chapter 8. Chapter 8 has sections 50 to 53. It talks about finance, audit, accounts. Any act or any institution or any body that's created and it has been conferred power to implement the law, it needs to be given certain financial assistance. And unless the financial assistance is there, such a body cannot function in itself. The sections 50, 51, 52, 53 deal with the manner in which the finances of the commission have to be handled. To get a general understanding of it, section 50 talks about grants by central government. This being a central legislation, the government of India is responsible for ensuring there are enough funds for allowing the functioning of the competition commission. Section 51 talks about constitution of a fund. Section 52 talks about accounts and audit, and section 53 talks about furnishing of returns, etc., to the central government. I think all these sections, section 50 to 53, speak for themselves. It not only talks about funds being sent to the commission, but also it talks about auditing in form of bringing about a transparency and filing the same to the government of India. Moving on to the next important chapter, chapter 8A of the Act. Chapter 8A talks about competition appellate tribunal. As it speaks for itself again, appellate tribunal. Let me put it in a simpler sense. This chapter seeks to provide the provision of appeal. In the previous chapters, you learned that the commission had the powers to pass orders, and the commissioner also had the powers to pass interim orders. The commission also has the powers to impose penalties. Perhaps sometimes it may not be correct that the commission would have passed right orders in accordance with law. Therefore, an aggrieved person aggrieved by an order of the commission or the Director General may prefer an appeal under this chapter. Let us examine as to how this chapter lays down the provision relating to appeal. Under this chapter, it has sections 53A to 53U. Let's go one by one to understand the appeal provisions of the appellate tribunal. For the purpose of understanding, first, it is required that there shall be an appellate tribunal created. It's a similar thing like Constitution of the Competition Commission of India. Section 53A, it talks about establishment of the appellate tribunal. Please try to understand the establishment in lines with the manner in which the Competition Commission has been established. Moving on, section 53B talks about appeal to appellate tribunal. Please note, unless there is a provision for appeal, you cannot prefer an appeal to the tribunal. Now, establishment of tribunal has been done. Under what provision do you prefer an appeal? Because each time you make an application, you will say, I have made an application under section so and so, seeking an appeal before the appropriate forum. Now, it is this section 53B that talks about appeal to appellate tribunal. We will get into what sort of orders can be appealed under this provision when I get into details of this chapter in course of my next sessions. Moving on, section 53C talks about composition of appellate tribunal. Just like we discussed in the Competition Commission, there needs to be a body comprising of certain members headed by a person, a chairperson, for the purpose of running the appellate tribunal. Section 53D talks about the qualification, which is also similar to the Competition Commission. The members of the panel, the members who are going to preside over the appellate tribunal, their qualification, who is the chairperson and the members are also said. And similarly, under 53E, there is also a selection committee. Selection committee's relevance would also be discussed in course of my next sessions on this chapter in detail. Moving on to section 53F. As I said, whenever you appoint a statutory body, authority of persons, they need to have a tenure, they need to have a pay, they need to have a term in which they are going to sit and work as functionaries of the government. Now, it is under these provisions that these details are laid down. Section 53F talks about term of the office of the chairman, chairperson and the members of the appellate tribunal. 53G talks about the terms and conditions of their service of the chairperson and the members of the tribunal. Section 53H talks about vacancies. Section 53I talks about resignation. This is again a common feature which has been similar to the Competition Commission, the resignation of a chairperson and the members of the appellate tribunal. Then 53J, the members of appellate tribunal to act as its chairperson in certain cases. Now, this is an interesting feature. Sometimes there is a vacancy of the chairperson's position. One of the members presiding over the appellate tribunal can assume the role of a chairperson and discharge the duties as a chairperson as may be required, but for the purpose of it, you need to be guided by section 53J and becomes relevant. Moving on, section 53K. 53K talks about removal and suspension of chairperson and members of the tribunal. Now, this is also important. Sometimes it may so happen that the members presiding over the tribunal may face a challenge or somebody may impugn their integrity. In such circumstances, how do we remove them? There should be a procedure to remove them. See, at every stage, if you look at the law prescribes as to how the administration of a government functionary should discharge its duties. Moving on, section 53L talks about restrictions on employment of chairperson and other members of the appellate tribunal in certain cases. As it speaks for itself, it's a common man's understanding. There's a restriction imposed on what sort of duties you need to discharge as a chairperson. Maybe things like holding an office of profit outside, certain restrictions of his, relating to his past or relating to off-chair activities. So, section 53L becomes relevant. Moving on, section 53M talks about the staff of the appellate tribunal. Even please understand the law. The law is very clear. It just not only talks about the higher-ups of the tribunal, but it also talks about its staff who are going to act as functionaries assisting the appellate tribunal to discharge its duties. So, therefore, it is all embedded into the Act, and the Act lays down a clear procedure of staff working for the appellate tribunal. 53N becomes relevant here. 53N talks about awarding compensation. Now, it is very important. Awarding compensation. See, appellate tribunal will have a power to uphold the orders of the lower commission, the Competition Commission, or pass a higher award, or it can also turn down the order and give a ruling saying that the order of the commission is not in accordance with law. Now, this power is conferred through section 53N. Basically, 53N talks about compensation, awarding compensation. 53O, it lays down the procedure and powers of the appellate tribunal. Just like the Competition Commission and its functioning, its powers and the procedure. Please note, the law always provides a procedure and the manner in which a body created under the Act shall function. See, I am laying emphasis on shall, because the section becomes a mandate, and the mandate guides the tribunal's functioning. So, therefore, the procedure and the powers of the appellate tribunal are also laid here. Moving forward, 53P, which talks about execution of orders of appellate tribunal. We might be reminded of execution of orders are passed by the commission. The commission has a power to execute its orders. Similarly, a power has been conferred upon the appellate tribunal to execute its orders. The execution of its orders and the power to it is conferred through 53P. This section is also relevant. Please note, when you confer a power to pass an order, you should also have the power to execute the order. This is where both the powers are conferred under this chapter to the appellate tribunal. Moving forward, section 53Q talks about contravention of the orders of appellate tribunal. This is also relevant. Passing of orders, number 1. 2. Executing its orders. And number 3. If you fail to obey the orders, then a power to ensure those orders are obeyed is conferred through 53Q. Contravention of the orders of the appellate tribunal. See, you have seen contravention. Whenever there is a contravention in form of penalties, and the earlier chapter which we discussed, it was quite detailed. Whenever there is a contravention of any of the provisions of the Act, then immediately the chapter on penalties will be invoked, and the enforceability order of the orders are done through imposing penalties. So, similarly, under section 53Q here, the contravention of the orders of the appellate tribunal, there is a penal consequences. Section 53R, vacancies in appellate tribunal, not to invalidate acts or proceedings. This is the relevant section. How is it relevant? Suppose A was appointed a chairman and B, C, D were its members. A, by virtue of resignation or removal from office, steps down, but his acts cannot be invalidated. So, any action taken in good faith are protected and covered under the section of section 53R. This section becomes relevant because the past acts of a person, a predecessor officer, presiding officer, his orders are protected by virtue of section 53R, and it becomes very relevant so far as enforceability of the orders are concerned. Section 53S, right to legal representation. This by statute even not provided, it is one of the cardinal principles of law that every person shall be given a free and fair hearing, and he also shall have a right to counsel. This is a constitutional principle where every person have a right to have a counsel and defend itself. But by a statute under the guise of section 53S, a right is being conferred on every person who seeks recourse before the commission to be represented by a lawyer of his choice. Section 53S provides for that. Section 53T talks about a provision relating to appeal to Supreme Court as against the orders of the appellate tribunal. In addition to this, there is a power conferred upon the appellate tribunal under section 53U to punish for contempt. So, if you observe the entire chapter from its beginning, from 53A to 53U, lays down a comprehensive understanding of the establishment of the Competition Appellate Tribunal, its constitution of its board, its powers, and the manner in which it should discharge its duties, and how it should be functioning. And also it confers the provisions when there is a contravention of its orders as to what would be the penalties imposed, and also provides for a special appeal to the Supreme Court in addition to the appellate tribunal. So, basic understanding of the entire chapter talks about the functioning of appellate tribunal and the rights that a person, an aggrieved person, would have in form of section 53B of chapter 8 of the Competition Act. Moving on to my next chapter and the last chapter, that is chapter 9, which talks about miscellaneous provisions under the Competition Act. This chapter has sections 54 to 66. Section 54, first section, talks about power of exemption. Now, this is the power that is enjoyed by the Government of India, where it can exempt certain non-application of certain provisions or application of the provisions of the Act to certain people. This section of it I will discuss in detail when I get into this chapter specifically in my next course of sessions. Under section 55, the government is conferred a power, the central government is conferred a power to issue certain directions to give effective implementation of the Act. Similarly, under 56, it says when there is a conflict, suppose power of issuing directions is conferred upon the commission also, but when a government also issues a similar direction, there would be a conflict of both the orders. In such cases, Section 56 clarifies, saying that the central government orders would supersede the competition orders. This is relevant. See, the ultimate power is vesting with the central government to guide the implementation of the Act. Moving on further. Section 57 is it talks about a restriction on disclosure of certain information. Now, there's a restriction of disclosure of certain information. Some information may be very confidential. For example, the policy of the Competition Commission which is undisclosed to public, which is under a very premature stage, or certain sensitive information which would adversely have an effect on the market, could be a restricted kind of information. But what is restricted information becomes very subjective, and then the Competition Commission decides. So therefore, there is an embargo in terms of law under Section 57 to put some sort of a restriction on disclosure of certain important information. Moving on to Section 58. Section 58 is a general provision, talks about the chairperson, the members, the director general, secretary, officers, other employees, etc. to public service. We'll also get into this section in the next course where I'm going to deal with this chapter in detail. Moving on to Section 59. 59 talks about protection of actions taken in good faith. All actions taken in good faith are protected under this Act. This is relevant because it confers certain immunity to the officers to discharge their duties without any fear from anyone. Moving on, Section 60, Act to have an overriding effect. Now, this being a kind of a special law can have an overriding effect on certain other laws. So therefore, this Act has to be seen as a special law enacted for the purpose of its objectives. I'll also give the interpretation of this section as I once again touch upon this chapter in course of my next presentations. Another important section, Section 61, talks about exclusion of jurisdiction of civil courts. This is very, very important. Most of you may understand the different kind of courts. Civil court is the most common court where people go to seek their remedies. Under the Competition Commission is the only court. So it says bar of civil court jurisdiction. Civil court is a regular courts what we generally see. Whenever you have an issue, you go to civil court. But when you have an issue on a competition related aspect, then you have to go only to the Competition Commission. Assuming if Section 61 is not provided, then people may think there are two jurisdictions for adjudicating their issues under the Act. Therefore, by imposing a restriction, it is taken off from the civil courts and put to the specialized body such as the Competition Commission to adjudicate upon issues that may arise under the Act. Moving on, Section 62 talks about application of other laws not barred. This is very interesting. Generally, sometimes whenever there is a special law, they say no other law should apply to the special law. But under the Competition Act, this section under Section 62, it clarifies that other laws have an application. Now, the question comes here. You may ask, why should other laws have an application? The clarity is this. The other laws will apply in addition to the Competition Act. When again I'll explain, you may ask me, how is it in addition to a Competition Act? For example, what are we dealing with? We're dealing with competition issues. And who are the players here? Who are the people who actually can create a havoc or cause an adverse impact in the market? It is huge companies which may have a lot of money, and their governance and their operations operate under the Companies Act, and there can be a trademark issue, there can be an intellectual property issue, or various issues that can come relating to agreements. Now, all these issues to be interpreted, you need to have support of other laws, because competition, as I said, is not defined under the Act. To understand competition, you need to take help of the other laws to interpret the issue and adjudicate upon it. That's why the other laws apply in addition to the Competition Act. This has to be borne in mind because it most often is taken as an objectionable issue, but this becomes a unique feature of the Act which becomes relevant for the purpose of achieving the objective of ensuring there is a good competitive environment. Moving on, Section 63 becomes another important thing. It talks about power to make rules. Yes, this is a delegated power, and who makes the rules? The rules are made under the Act to give effective implementation of the entire Act. Rules are ancillary to the Mother Act, and the main Competition Act will function in form of enacting rules for itself. Going further, 64 also something like that, which talks about power to make regulation. Rules and regulations are powers which are a delegated legislation, passes upon the Competition Commission and the government, central government, to make appropriate rules from time to time to give effective implementation of the Act. Section 65, the next section, which is also important, which talks about power to remove difficulties. Now, remove difficulties, sometimes there may be certain errors. It's like judge being conferred a power to correct his own orders. Power to remove difficulties is also conferred through the Act upon the agency created under the Act to remove all such difficulties which come in way of effective implementation of the Competition Act. Moving forward, the last section deals with repeal and savings wherever required. Like in course of my session under various chapters, I said certain sections have been omitted or repealed. Using this section 66, certain provisions can be repealed or as may be required for the purpose of giving effective implementation. As observed, this chapter 9 becomes very crucial. What did you learn through this chapter? Chapter 3 becomes relevant because it lays down what is the role of central government in implementing the Competition Act and what happens in case there is a conflict of orders between the Competition Commission and the government, whose order prevails. And going forward, it also talks about things such as bar of civil jurisdiction, bar of civil courts jurisdiction. It also talks about conferment of certain powers upon central government to ensure certain rules and regulations are made for the purpose of effective implementation of the entire Act. Therefore, you must bear in mind the manner in which the entire Act is structured to ensure that at every stage there is no hindrance to given effective implementation of the Act. I will conclude this session here and move on to the next sessions where I am going to go in detail of the 9 chapters selectively for the purpose of a better understanding of each section with its intricacies.